loan modifications, worked out considerations, and alternatives to judicial foreclosure. And obviously, with the increased stress in the agricultural segment, hopefully this information will allow you to, I think, timely, properly, and efficiently respond in situations where you have non-performing yet still cooperative borrowers. So once you've truly identified a stressed agricultural credit, it truly is important to address it ASAP. So you need to analyze the file, you need to examine the options, and then ultimately come up with a plan. A particular situation may merely call for a modification, as Jeff kind of alluded to, or maybe a forbearance agreement to give the borrower some short-term relief to get through what may or may not be just a temporary rough period. But once you've reached a point, though, where collection and enforcement against the collateral is necessary, I've identified some non-judicial alternative procedures that can save a lot of time and money, especially in the agricultural setting when you're dealing with certain statutory mandatory mediation, 1 year right of redemption, and then rights of repurchase upon the ultimate sale of the property once you have it back. So analyzing the loan file. The first step before considering any real modification, forbearance, workout, or the like, you or your legal counsel should probably make sure to review and analyze the file and attempt to identify any inconsistencies, any missing information, or other potential enforceability issues. Jeff alluded to some of those on the front end as far as the documentation area, but then this is an opportunity, like he said, to kind of button up some previous mistakes or add to the documentation there. So if there are issues identified, this is truly the point when you have a cooperative borrower that's willing to not do as you say, but he's willing to ultimately adjust the arrangement. That's where you can, again, button up these issues on the back end. So I'll just briefly touch on these items because Jeff went through it previously, but proper parties and signatures, obviously you want to confirm that the proper parties are named and have signed all the appropriate documentation. Proper notarizations. So defective notaries are another item that can be kind of an issue, and that's truly because some minor yet fatal issues in the notary can allow a bankruptcy trustee to seek to avoid certain mortgages using their strong arm authority. Legal description errors, again, Jeff talked about, but it's best to button up any known or maybe originally unknown errors in the legal description at this point in time, as compared to trying to reform that mortgage in any real piece of litigation. Default notices. So where agricultural real estate's involved, you need to send 45-day right to cure notices, which that runs in concert with the 45-day mandatory mediation period. I'm guessing Molly Pulaski may have touched on those items earlier, so I, again, just make you generally aware at this point. Inconsistencies between the note and mortgage. So you want to verify that the mortgage terms clearly secure the particular indebtedness, especially a lot of times you're dealing with replacement or alternative notes. Loan history. So you want to make sure you're comfortable with the note history, the accounting of the payments received, interest rates, etc. So minor errors with those items ultimately on the back end can prevent summary judgment, and thus, again, it's best to fix them as part of any real workout. Lender liability claims. So you need to examine any potential lender liability claims, which those typically come in the form of oral promises to lend additional funds or a promise not to foreclose. So again, it's important to sit down with any loan officers that have been on the file and make sure you're aware of any and all oral or written promises that have been made to the borrower. Collateral value concerns. You should analyze the value of the collateral, obviously, in relation to what the outstanding indebtedness is. Whether the loan is upside down or whether there's equity in the collateral will have a direct bearing on whether you need or want to pursue guarantors, deficiency judgments, etc. And similarly, you should evaluate the financial position of the borrower, or I suppose guarantor as well, which may dictate the form of workout you pursue at that point as well. So moving on to loan and mortgage modifications. So oftentimes, the first request from stressed agricultural borrowers is for a simple modification, which essentially gives them more favorable terms as far as repayment. This can be an effective tool when you're dealing with highly variable commodity prices, and it gives the lender a chance to get repaid in full, assuming the borrower can regain his or her financial footing, which a lot of times is a big if. So formal modification of mortgages is essentially required where there's an extension of the maturity date or where the secured obligation is increased. Due to certain statute of limitation considerations that affect enforceability of mortgages, whenever the maturity date is extended, the recorded mortgage should also be amended to update that information. And this is because Iowa Code essentially provides that mortgages are unenforceable 10 years after the maturity date if the maturity date is stated in the mortgage. And additionally, if the maturity date is not included in the mortgage, then the mortgage is unenforceable 20 years from the date of the mortgage. So again, where there's an amendment to the maturity date, you need to amend the mortgage. As lenders, you also want to formally amend any mortgage if the secured amount is increased over and above the originally stated amount. So this is typically done to take advantage of the future advances priority, which is given under the Iowa Code, which affords priority to future advances up to the stated amount in the mortgage. So obviously, if the amount increases, you'll want to amend the mortgage to reflect that, to take advantage of that future advances priority. There is specific language provided for in the Iowa Code. I believe it's 654.12a. That needs to be included in the mortgage to take advantage of that. So if you don't have that, certainly let us know and we can shoot it to you. So let's look quickly at some potential priority issues. So the general rule is that a senior lender doesn't lose priority if it modifies a mortgage, except to the extent that it materially prejudices junior lien holders. And typically the penalty for that is loss of priority. So not surprisingly, whether or not you're prejudiced depends on the facts and circumstances of the case. But clearly, it's been acknowledged that increases in interest rates, increases in the amount of debt, and a reduction in the repayment period are considered prejudicial. So for example, if the interest rate on the existing mortgage is increased from 5 to 10%, that additional 5% interest may not have priority over recorded liens that are recorded after the original mortgage, but prior to any modification. So alternatively, decreases in the interest rate, reduction in the total loan amount, or an extension of the repayment period typically benefit those junior lien holders. So you aren't going to run into any priority issues there for those types of amendments. In an effort to avoid the materially prejudicial modifications, there is language that you should include in your documentation that expressly allows you the right to modify. And can again help to overcome loss of priority even in those scenarios. So I have some specific recommended language that isn't currently in most, bank form mortgages that I typically like to include. So again, feel free to reach out to us if you'd like some examples of that language or that language specifically. And then quickly, when is a guarantor's consent required or recommended when you're modifying a note or mortgage? So consent typically is not necessary since most guarantees are continuing and cover extensions or modifications. However, a guarantor has still been discharged in situations where essentially they deem the modification a substituted contract, or if it imposes a fundamentally different risk than what the guarantor took on initially. So therefore, kind of in abundance of caution, to avoid any such risk, it's generally our recommendation that good practice would just have the guarantor also consent to any modification to the note. So moving on quickly to forbearance agreements. So the basic concept of a forbearance agreement is that the lender agrees to forbear from exercising its remedies, provided that 1, no further default occurs, and 2, that during the forbearance period, the borrower takes certain steps to address the loan repayment or collateral concerns. The forbearance agreement is typically a strong indication that the future of the particular credit is limited, at least in its current form. So it allows some sort of adjustment there to hopefully get on a plane where everybody can make good on the promises and ultimately the bank can get repaid. in my experience, many forbearance agreements are negotiated over the course of weeks, maybe even months, but a lot of times never actually get entered into. So what I typically recommend, and I know this can be tough, but I typically recommend that lenders should consider sending the required 45-day notice, scheduling the mandatory mediation, and ultimately filing the collection action. That action can always be dismissed if a forbearance or workout's agreed to, but if it's not, then ultimately you haven't lost any time moving forward. Again, I realize that can be tough, especially from a client relationship standpoint, to move forward so quickly as far as litigation or the prerequisites, especially when you got these long-time agricultural borrowers. But again, I think with proper communication, it's typically the best and most prudent move. So we'll look quickly at some key and recommended provisions for these forbearance agreements. Okay. First, an acknowledgement of the validity of the loan documents. You should insist that the borrower expressly acknowledge the validity of the loan documents. This kind of serves to remove enforceability claims later on. An acknowledgement of default. So should litigation commence, you don't want to argue over the existence of a default. Thus, you should typically require that the borrower admit the specific nature of the default and also acknowledge that all statutory or contractual notices have been provided or otherwise waived. The amount of the indebtedness, so you should also include there and have the borrower confirm the amount of the indebtedness at the time of the forbearance agreement. Again, you don't want to argue about that after the fact as to what is owed and when. The waiver or release of claims. So one of the key benefits, a lot of times critical components of the forbearance agreement, is that the lender obtains or should obtain the borrower's release from prior claims against the lender. It kind of puts the borrower in a critical position where if he thinks he has legitimate claims against the lender, ultimately he needs to decide whether he wants to pursue those claims, reserve those claims, or move forward with the forbearance agreement and get the additional time. Forbearance period, obviously, each forbearance agreement provides for a specific amount of time for the borrower to essentially implement their given strategy. That can be 60 days, 6 months, a lot of times maybe even up to a year in these agricultural settings. So in addition to kind of those primary provisions, there are also some recommended provisions. Forbearance fee, your attorney's costed a whole heck of a lot. So a lot of times lenders will charge a forbearance fee to cover those out-of-pocket expenses. A bankruptcy provision. So a covenant not to file bankruptcy is enforceable against public policy. But what I typically do, I include a provision that makes it clear that the forbearance agreement is effectively void in the event the borrower files bankruptcy and the payments are set aside. Certain covenants of the borrower. So you should capture the borrower's promises to execute their preferred or requested strategy. So again, they may covenant to list certain collateral for sale. Other promises include turning over documents, paying off other claims against real estate or collateral, or otherwise maybe directing rent payments directly to the lender. Remedies. So the agreement should also make clear that the lender has the availability of all remedies as set out in the loan documentation, and then specifically in the forbearance agreement, you can also come up with some unique or unusual remedies potentially, which may involve maybe placing a confession of judgment in escrow. So that covers, for the most part, forbearance agreements. I'm going to talk now just quickly short sales. Let's see how we're doing for time. So short sales, they're fairly straightforward for lenders. Its primary role is providing the closing agent with a payoff statement, which you're agreeing to take less than essentially what you're owed. So it's a reduced payoff in exchange for the release of the mortgage on the property. So for loans secured by real estate strictly, the short sale typically accompanies a debt settlement agreement, which sets forth the full agreement of the parties. So for example, even though the lender has agreed to take less than what is owed, that debt settlement agreement may reserve a deficiency, and that deficiency typically we see takes the form of an unsecured deficiency note. And that debt settlement agreement is also a useful tool. You can include a lot of the standard provisions we talked about earlier with forbearance agreements. But essentially, instead of providing the framework for relationship moving forward, the short sale, in essence, provides an opportunity to truly settle and end the relationship. The voluntary non-judicial foreclosure process, and that is found in Iowa Code Section 654-18. So unlike the traditional judicial foreclosure, the primary benefit of the voluntary procedure is that it removes all junior liens and obtains marketable title in approximately 30 days. The only real drawback is that the lenders must waive their right to pursue the mortgagor or borrower for any deficiency. So if a deficiency is desired, the deed in lieu process is typically the recommended route. And we'll touch on that after this. So with agricultural land, the mortgagor is typically entitled, as I alluded to earlier, the rights of first refusal and repurchase under Iowa Code Section 654. Thus, again, this agreement should include specific provisions waiving those rights. And the written agreement, which we'll talk a little bit in more detail here, essentially provides an opportunity for the parties to again include provisions commonly found in those settlement or workout agreements, which, as we talked about, may be release of claims, assignment of rent payments, etc. So moving on to, I'll call them the structural requirements for voluntary non-judicial foreclosure. So the statute requires the parties to file what they call a jointly executed agreement, and you file that in the county where the real estate is located. And that agreement expressly states that the parties have elected the non-judicial voluntary procedure under the Iowa Code. It also includes a written notice and disclosure wherein the borrower has a right to cancel the process, and they have that right to cancel for 5 days after delivery of that notice. But if it's not canceled, then essentially the foreclosure becomes final, subject only to the 30-day right of redemption for junior lien holders. So along with that written agreement, and contemporaneously with the filing of that agreement, the borrower conveys to the lender their interest in the real estate that's subject to mortgage. The statute doesn't dictate the nature of that conveyance, but we typically see and want a special warranty deed there. But even though the deed is filed and the agreement's filed, the completion of the non-judicial foreclosure is again contingent upon that expiration of the 30-day right of redemption period for junior lien holders. So getting to that, once the parties have entered into that foreclosure agreement, they have the deed, then the lender provides notice to all the junior lien holders of the election of the non-judicial process. And that notice essentially informs those junior lien holders that the parties have agreed to foreclose the mortgage under the voluntary process, and that each junior lien holder has 30 days from the mailing of that notice to exercise any right of redemption. If they don't timely redeem, essentially their lien is extinguished and removed from the property. So to kind of bookend that, to complete that foreclosure then, the lender generally files an affidavit attaching copies of the notice to the junior lien holders, stating that no party exercised its right to redeem, and also stating that the borrower did not exercise its right to cancel the foreclosure agreement within that 5-day period. And that's essentially your 30-day voluntary non-judicial process. We've got a few more minutes. Deed in lieu of foreclosure, I alluded to it a little bit earlier. It essentially allows the lender to take immediate title to the property. The drawback is it doesn't eliminate or deal with any junior lien holders or liens that may encumber the real estate. So again, if junior liens exist, you'll want to consider the voluntary non-judicial procedure, which can scrape those off. With the deed in lieu, there's no requirement for notices of right to cure or mediation prior to accepting that deed in lieu. And in contrast to the voluntary non-judicial process, the deed in lieu procedure does allow the lender to accept a deed and still pursue a deficiency if the parties so agree. So So a lot of times people think, oh, we just need a deed in lieu for the property to come back to us. You're also going to want a written agreement with that as well. And that'll spell out, again, if you want to retain a deficiency, but more, I guess, appropriately, it also waives the borrower's rights of repurchase, rights of first refusal, et cetera, that kind of tag along with agricultural loans. So it's more than just a deed. You'll want another written agreement setting forth the agreement of the parties. So there is little, I guess, language that we require in all deeds in lieu. So first, in Iowa, essentially, where the mortgagor deeds the property back to the lender, the general rule is that deed is presumed to be a continuation of the security, and thus the right of redemption continues. So that presumption can be overcome if the deed explicitly states that the conveyance is absolute, for valuable consideration, and not given as additional security. So that language should be specifically included in the deed form. Additionally, the deed should also include a statement that the mortgagor believes the value of the real estate is less than or equal to the amount of the indebtedness being released. And this is because, essentially, if the mortgagee transfers equity in the property, there isn't reasonably equivalent value. So if the mortgagee then files for bankruptcy after the fact, the bankruptcy court may seek to avoid that transfer as a fraudulent conveyance. So again, that's important language to include in that deed in lieu as well. So I think we're running out of time, but that was just, again, kind of a brief description of the non-judicial options when you have a cooperative non-performing borrower. And hopefully that gives you, again, just some helpful information in dealing with those stress loans. And you can feel free to contact us with any questions.
Thanks, Ben. And if what Jeff has advised you to put in your agreements hasn't solved your problem, and if Ben's non-judicial options haven't solved your problems, you end up talking to somebody like me. I